Okay, good afternoon, everyone. And I want to welcome the officials from the Ministry of Planning and Development, the Ministry of Rural Development and Local Government, the members of the media, and the general public to this meeting of the Public Administration and Appropriations Committee of the Parliament. I am Bridget Anisette George, and I'm the chairman of the committee. The Committee on Public Administration and Appropriations has a mandate to consider and report to the House on A, the budgetary expenditure of government agencies to ensure that expenditure is embarked upon in accordance with parliamentary approval. B, the budgetary expenditure of government agencies as it occurs, and to keep Parliament informed of how the budget allocation is being implemented. And C, the administration of government agencies to determine hindrances to their effectiveness and efficiency and to make recommendations to the government for improvement of public administration. The purpose of the 20th public meeting of the Public Administration and Appropriations Committee for the 11th Parliament is to seek further information on the approval process for land use in Trinidad and Tobago as it pertains to the following: the policies in place to guide the approval process for land use, the systems in place to monitor all levels, residential, industrial, commercial, and agricultural, of developments, and the capacity of state agencies responsible for monitoring land development. The committee is desirous of hearing from key officials of the Ministry of Planning and Development and the Ministry of Rural Development and Local Government to discover the challenges being faced and to determine possible solutions to these challenges. The role of the committee is to assist the ministries to achieve the efficient delivery of services while ensuring that expenditure is embarked upon in accordance with parliamentary approval. This meeting is being held in public and is being broadcast live on the Parliament's Channel 11, Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. Viewers and listeners can send their comments related to today's inquiry via email to parl101@ttparliament.org, facebook.com/ttparliament, and Twitter @ttparliament. I will now like to invite the members of the Ministry of Planning and Development and the Ministry of Rural and Local Government to introduce themselves. And I will start with the Permanent Secretary of the Ministry of Planning and Development and to introduce your team, and then we'll go on to the Ministry of of Rural Development and Local Government.
I'm the Sterling Chidi, the Acting Permanent Secretary of the Ministry of Planning. I have on my left Ms. Marie Hines, Deputy Permanent Secretary, Dr. Ansel Cook, Director of Tongue and Country Planning, Ms. Camille Gouchard, Assistant Director, Tongue and Country Planning, Ms. Fortune Bullock, Assistant Coordinator, Tongue and Country Planning, Ms. Renal Sargent, Senior Land Use Planner, and Mrs. Penco, Acting Director of the Planning Unit.
Thank you very much. And the Permanent Secretary for the Ministry of Rural Development and Local Government.
Good afternoon, Chair, esteemed members. I am Stara Ramlogan, Acting Permanent Secretary, Ministry of Rural Development and Local Government. I would like to introduce you to the team on my right. Mr. Jamil Amiral Chedi, the CEO of the Shogunas Borough Corporation. Ms. Aisha Donaldson, Senior Regional Planner, Local Area and Regional Planning Unit. Mr. Dheeraj Ramtahal, our Acting Building Inspector to Port of Spain Corporation. And to the rear, Mr. Francis Spear, Acting Building Inspector to Sandy Grande Regional Corporation. Thank you.
You're welcome. And I'll now ask the members of the committee to introduce themselves, starting with my extreme right.
General Ansel Antoine, member.
Clarence Rambarat, member. Daniel Duki, member.
Garvin Simonet, member.
I will, in opening, ask Mr. Sterling Chady, the Acting Permanent Secretary in the Ministry of Planning and Development, to make an opening statement, and will therefore then ask Ms. Stara Ramlogan to follow with her opening statement. Thank you.
Good afternoon, Chair, honorable members, ladies and gentlemen. The Tongue and Country Planning Division of the Ministry of Planning and Development thank you for this opportunity to appear before you today and to be of assistance to the committee. Established in 1963, the Tongue and Country Planning Division is responsible for the administration of the Tongue and Country Planning Act, Chapter 3501, on behalf of the Minister with responsibility for Tongue and Country Planning. The division seeks to ensure orderly, consistent, and progressive development of all land in Trinidad and Tobago. It also seeks to promote sustainable forms of land use through proper spatial planning within the framework of the law and of national and international imperatives. The dedicated staff of the Tongue and Country Planning Division operates out of the head office in Port of Spain and through 4 regional offices located in South, East, North, and in Tobago. The TCPD undertakes 2 core but interrelated functions, namely development planning and development control. Development planning includes the preparation of national, regional, and local area plans, the preparation of land use policy maps that designate the type of land use that are permitted in a particular area, and the development of planning standards, policies, and guidelines. The primary objective of development control is to ensure that the development as defined in the Tongue and Country Planning Act is consistent with policy and developmental plans. Development control includes the processing of applications for planning permission to develop land. 2 forms of planning permissions may be sought by an applicant. They are outline planning permission and final planning permission. As required by law, final planning permission, together with the required approvals of the local authority and other relevant state agency divisions or departments, must be obtained before any development of land must be carried out. It is therefore a breach of the law to undertake development in Trinidad and Tobago without first obtaining required planning permissions. When development occurs without planning permission or is implemented contrary to approval granted, the minister may, within 4 years of the development being carried out, have an enforcement notice served on the owner or occupier of the property. The enforcement unit of the Tongue and Country Planning Division treats with complaint matters related to any unauthorized development activity. In closing, we wish to indicate that the Tongue and Country Planning Division is continuing its efforts to improve the efficiency and effectiveness of its operation, and to assist Trinidad and Tobago to improve its rating on the Ease of Doing Business Index. Hence, the division is currently involved in a number of initiatives. These include 3 key projects, namely the automation of the construction permitting system, the digitization of the Tongue and Country Planning applications, the improvement of service delivery infrastructure at Tongue and Country Planning, the implementation of a complex development facilitation committee that includes persons from other government agencies to assist with major or complex development proposals, and the review, updating, and development of our policy standards. Ladies and gentlemen, the town country has been operating within an environment of major resource constraints and reduced funding as the country deals with its overall budget constraints. However, right, such dedication and commitment are without limits. Further, currently the future of the division is being reshaped in light of the pending full proclamation of the Planning and Facilitation Development Act 2019. But the staff of the Town Country Planning Division continues to faithfully play its part in the approval process for land use in Trinidad and Tobago. Thank you.
Mr. Ramlugan.
Good afternoon, Chair, esteemed members of the committee, and the general public. It is my team's distinct pleasure to participate in the proceedings of this inquiry into the approval process for land use in Trinidad and Tobago. The Ministry of Rural Development and Local Government is guided by the Municipal Corporations Act number 21 of 1990 and its Amendment Act number 8 of 1992 in its oversight responsibility to local government bodies. The ministry is responsible for facilitating, coordinating, monitoring, and ensuring accountability of the municipal corporations in the efficient delivery of quality services through the optimum use of resources, decentralized systems, structures, and procedures, and the provision of specialized support services to facilitate balanced growth and development. We are privileged to have a more direct connection to our citizens than central government, which is unique and critical to the democratic process and a major catalyst in the execution of any citizen-centric national initiative. The corporations, in the exercise of its functions and powers as it relates to land use approvals, operate within the confines of the established legislative, regulatory, and administrative framework through its authority laid down in the Municipal Corporations Act, Chapter 2504, the Town and Country Act, Chapter 3501, the Public Health Ordinance, Chapter 1204, and relevant building regulations. The Ministry of Rural Development and Local Government is presently in a state of transformation and modernization consistent with the draft policy transitioning of local government approved by the Cabinet in September 2016. The ministry has been working assiduously with the Ministry of Planning and Development to ensure the implementation of a decentralized land use planning system and an automated development permitting system. With the recently assented PAFT Act and consistent with local government reform, a streamlined regulatory system, merging planning and building approvals within a more integrated process is anticipated as local government bodies become more involved in the planning and development of communities. It is expected that through our deliberations here today, we can determine the effectiveness of the existing legislative, regulatory, and administrative framework of the approval process for land use. It is also anticipated that through our collaborative efforts, we can identify the existing challenges, deficiencies, and constraints, which can inform the recommendations moving forward required to improve the governance structures, systems, policies, and procedures with respect to the same. Good governance requires credible and trustworthy institutions built on principles of efficiency, transparency, and accountability. Thus, the role of local government is critical due to its direct relationship with communities, and it is not merely about us delivering a service, but doing so in an efficient, timely, accessible, transparent, and accountable manner. In conclusion, we are here today to provide any information or clarification, personally or in writing, that you may so require. Thank you.
Thank you, Madam Permanent Secretary. So that really, I would like to start off the conversation with something that I've heard in both opening statements. And I think it may be fair to say that there is a sort of dual responsibility vested in the Town and Country Planning Division and the Ministry of Rural Development and Local Government for land development in Trinidad and Tobago. So that really I wanted to find out from you all what sort of relationship exists between the entities, and are there any formal structures for collaboration between you all?
Yes, Madam Chair, members, we do have formal structures in terms of committees, technical committees that have been set up and established to deal with common issues between the two organizations. And with respect to land use planning approval, Ministry of Planning has the responsibility with respect to land use development, but those approvals or applications are conditional to the local health authorities' approval. So our responsibility starts after the planning permission is granted, because it's normally conditional to the local health authority, under our authority with respect to the public health and environmental matters. So structural integrity of the buildings, the physical infrastructure with respect to the roads and drains, and the structural integrity of the same.
Okay, so that in terms of determining land use, there's no role for your municipal corporations or your ministry in terms of land use?
With respect to the developments of the development plans that Town and Country Planning, develop, there is a consultation process that takes into consideration all stakeholders, including the Ministry of Rural Development and Local Government.
These development plans would also deal with land use?
The development plan is about land use. It's about taking the potential and constraints of the country in terms of the site and determining what is the optimum land use based on the socioeconomic and physical analysis of the area.
Okay, and therefore might I ask then the Permanent Secretary in Town and Country, apart from the Ministry of Rural Development and Local Government, who are the other stakeholders with whom you'll consult to come up with your land development plans?
Well, most of the land development policies and so forth would follow from our national development plans. I think the last one is fairly old. But what would have happened is over time, we would have engaged with a number of persons in terms of developing and making adjustments to these plans. Right? Dr. Cook, you want to help me here?
Chair, as the PS has indicated, we would collaborate with sister agencies, because in developing our plans and policies, we would need the input from the various government agencies. We would also need input from the members of the public, so that in developing these plans, we would have had consultations with the members of the public. And as I said before, all the relevant agencies, whether it be the Ministry of Works as it pertains to drainage, WASA as it pertains to water and sewage issues, so that those are the other players, that other stakeholders that would be involved as we seek to develop those plans.
So maybe I could get a little clarification. First, I'm told that the National Development Plan is an old one, but then I hear us talking about consultations and changes, and now I hear us talking about plans. So maybe I need a little sort of clarification. If we have a plan, is it that the plan has been updated from time to time? that the basis of the plan remains the same, and therefore the plan is just being tweaked to reflect new realities? Or is it that it's still the same old plan? Or what are the other plans we're talking about? I'm not sure. So maybe we could get this opportunity so that not just the committee, but the public will understand, what we're talking about.
Chair, the National Physical Development Plan, which is the statutory plan developed, I think it's 1984, and that was taken to Parliament, and so it's a statutory plan. That plan would involve planning at a regional level, planning at a local level. So what happens subsequent to the National Physical Development Plan is that regional plans would be developed, local area plans would be developed, so that there may be a plan for St. Helena, a plan for San Grande, as the case would be. And all of them would be consistent with the National Physical Development Plan. So that whilst there would not have been a more recent statutory plan, in 2013, for example, the National Spatial Development Strategy was approved by Cabinet, and that would have been an attempt to update the national plan, albeit it was not taken to Parliament. But again, that, based on current realities, would have helped to make planning more relevant to what is happening today. So that whilst we have the National Physical Development Plan from then, there's a constant reviewing of standards, reviewing of policies, as we said, based on international imperatives, based on national development demands and so on. So that those are current and they continue to be developed, as we said, with input from relevant agencies and with input from members of the public, whom we would have consultations with from time to time.
So these reviews, how periodic are the reviews, and when was the last review?
The reviews are continuous, so that as we speak, we are reviewing our land use policies. We would have had our current policies last review, formal review would have been 2009, and currently we are in the midst of reviewing the land use policies for all of Trinidad and Tobago, especially in light of the pending devolution of planning authority to the regional corporation. So as we speak, we are in fact reviewing policies for various areas, albeit not the larger national physical development plan, but we constantly are reviewing policies.
So with these constant reviews, would then the overall plan still be applicable, still be relevant?
I have had sufficient people, including planners, who say much of what was done in that 1984 plan still remains relevant. However, it's one of the purposes of the National Spatial Development Strategy in 2013 was to look at planning from a more strategic point of view as opposed to the more detailed approach of the NPDP. So that way we ensure that we are constantly on top of what is happening in the society, so that the plans still may remain relevant, but ultimately it's hoped that the National Spatial Development Strategy, for example, is taken to Parliament and becomes the next statutory plan by which planning is going to be guided going forward. But of course, that would be something to be taken forward by the relevant minister, well, in this case, our minister, as required.
And I just want to ask you one other question on what you said in terms of consultation with the public and ask how you decide on what parts of the public would be selected for consultations, and when was the last consultation with any segment of the public?
If we are doing, the plans that we would have been doing within recent time are more those local area plans. So that we would have done, and our Deputy Permanent Secretary might remind me of the actual year, that we would have done St. Helena. Now, if you're doing, for example, a local area like St. Helena, you would obviously need to consult the residents. St. Helena being an area flooding, drainage issue, so you would then decide that you need to consult agencies like the Ministry of Works, and so the Drainage Division and so on. So who you consult would depend on the area that you're doing that plan for. As I said, we have not done at the national level, albeit when we looked at the National Spatial Development Strategy, there was consultation. There were consultations throughout the country dealing with the various communities, all right? And as I said, that one would have been done in 2013. Anything else is at the local area, and as we develop those plans, we would consult with the relevant people.
Yeah, but I understood that in terms of, and that's why I asked specifically, how do you select your public? So, for instance, you're saying the local area, I don't expect, and I might be wrong, but I didn't think you would have resources to consult every resident. So that is your selection process that I'm concerned about. I heard you speak about agencies. So it was really geared at the public, because I guess in agencies, apart from whether it's fire or WASA or whosoever, I guess you will consult the municipal corporation. So I'm trying to find out what is your selection process for the members of the public? So if you want to use St. Helena, how do you go about selecting that?
All right. I will let the Deputy PS take it here, since she was directly responsible for it, so she will be able to respond as well.
Good afternoon. So we tried some creative methods, I recall, with St. Helena. Not only did we do the usual, depending on the community, I mean, we actually went out with the man with the loudspeaker who announces that we are coming, depending the nature of the community. And St. Helena is a good example because it's sort of rural-urban. So they will know we are having a meeting in a particular vicinity, they will come out. But in addition to that, we would have done flyers, posted things everywhere known to man, and also place information, leaflets in post boxes. So in that particular scenario, an example, we are not picking and choosing. It's not like a survey where CSO is going out and deciding that they're going to sample 10% of the population. It's not that. It's a concerted effort to get to every household. That's one. In addition to that, we liaise very closely with the Ministry of Community Development, who would have a list of community-based organizations. We would speak to whoever has a list of NGOs, and we've been doing this for a while in the Ministry of Planning. So we have lists, and we will send the word out, yes, via email. We have done talk shows. I have been on talk shows saying we are coming. And in particular, it's very important to put ads out in the papers so that they know that when they see these people in their spaces, you can trust them. We're coming to ask for information. We are coming to give you the opportunity to tell us what you would like. So that's just one example. We've done land use updates in Trinity. Again, a different kind of environment. Woodbrook, another kind of environment again. So you try to come up with strategies that meet the sort of context in which you are trying to do a plan or update land use standards for that area. So that's just an example of some ways.
Very much. Member Ramraj, you want to ask any question?
Yeah, just in anticipation of the full proclamation of the planning and facilitation of development legislation, I just wanted to find out what are the key changes that you expect to take place in the country?
Okay. Well, one of the key changes, as we look through it, is really the moving of the concentration of the Planning Action Authority from the Town and Country division itself. This is one of the big things, towards the various local government regional corporations, so that the regional corporations themselves will be invested with the authority to do the current things that Town, Country, and Planning does. However, with respect to the much larger operations and so forth, there will be a planning authority that will oversee the authorization and planning control for very large and complex operations. Right?
Okay. I have you here, Mr. P.S., I just wanted to find out a bit and to switch the conversation a bit to your planning permission process. And you had identified 2 stages, your outline planning approval and your final planning approval. And in your submission, we were given something like a process chart, a flow chart. Is a timeline attached to these processes?
There is a timeline attached in terms of the outline. Of course, the outline planning permission is not really a final planning permission. However, this gives...
You may wish to speak to what outline planning permission is, because remember we're talking to the public, so you may wish to say what it is.
Okay. Well, outline planning permission is really a planning permission that says, okay, you could begin to proceed with this development. However, you need to supply a certain number of documents, look for deeds, and there's a list of documents that you need to supply with the outline permission. And having supplied that, then you can move to the more final planning permission.
So if I got outline planning permission, what would that mean? What can I do? I know if I get a learner's permit, I know what that means. What does an outline planning permission approval mean?
Okay. I defer to Dr. Cook.
Thank you very much, PS. An outline planning permission says, once it is approved, says that from a land use perspective, the development can in fact take place. The outline approval would give conditions which would need to be met. It would indicate standards that would have to be adhered to, and it allows the applicant now to take that permission and then prepare drawings and final plans for submission. With the outline planning permission or the outline application, it allows you not to expend monies by preparing plans, drawings, which are expensive things, only to find out that it would not be approved. So you submit your outline application, you are given approval, so it's an outline approval. It is valid for 1 year. It would give the conditions that you would now need to satisfy, so you go prepare your final drawings. In some cases, it would say to you that before you could submit your final drawings, you need to get permission from WASA. You need to get permission from fire, as the case would be. So you get all those things, then you prepare your final drawings, and then you submit those now. An important thing to bear in mind is that development cannot begin with only an outline planning permission. Actual work cannot begin with an outline planning permission. It's only after you abide by the standards and guidelines, you prepare your drawings, and you get permission, what we call sometimes full or final planning permission. And even then, there would be conditions that say you need to get the approval of some other agencies and finally that of the local authority. It's only after that is granted, then you can begin development.
Member Tukey.
Thank you, Madam Chair. Dr. Kirk, you said, if I got you correctly, that actual work cannot begin with an outline approval. Is it cannot begin or should not begin? In other words, do we have instances where work actually begin on the premise of an outline approval?
Actual development cannot, should not, must not begin with an outline approval.
But in practice, does it occur?
It occurs.
And what,
which, of course, is contrary.
What are the remedies to such violation, for want of a better term?
That brings into question the whole issue of the enforcement procedures, so that if there is a development that takes place without planning permission and it is brought to our attention or we discover it, then action can be initiated to take what we call enforcement action against such person or persons who would have begun development. And it has happened, it does happen, without getting that final plan permission.
And a follow-up to that, Madam Chair. You said action can be taken, and sometimes action is taken. Is there consistency in the actions that are taken? So, for example, if a violation of the sort occurs in one particular region and a similar one occurs in another particular region, is the intervention consistent throughout?
The intervention is supposed to be consistent, but insofar that we are aware of the violation, so that if we are not aware of the violation, then we can't take action. Sometimes we might pick it up ourselves. Sometimes people might submit a complaint about something that is happening. Then the enforcement unit goes out, investigates, and a letter of advice is sent to the person, as the case may be. So that the actions are supposed to be consistent, as I said, insofar as we know of the infringement.
Insofar as you know. So my follow-up question to that, Dr. Kirk, is that what is done to monitor and ensure that there are no violations? And maybe that could be extended not just to outline approval, but to final approval. Okay. Let's limit it to outline approval.
In the
Because you said as far as you are aware.
Right. In the ideal world, you need staff and resources to be able to keep up with what is happening outside there in terms of persons violating and infringing. And of course, also we work along with our colleagues at the local government, because action can also be taken there as well. So you need resources to be able to deal with every infringement that is outside. And I can tell you that that is just not possible. We barely have the resources to manage the over 8,000 applications that we receive on a yearly basis. We would like to. The enforcement unit right now is staffed by just 10 persons, and they are contract persons. And we are trying to use those persons to cope with it. But you could well imagine 10 persons for all of Trinidad and Tobago is just not happening. So I'm saying, as far as possible, once we see infringement, we deal with it. But to be able to do that consistently everywhere you see something is happening is near impossible. do that.
So, thank you. I just wanted to come back to the question with the flow chart from where you've shown from submission of an OPP to the assessment of the request. How long is that likely to take? And we're talking, I'm sure it will differ, but you have a flow chart showing every step in the process. What are the timelines attached to that?
I may not be able to give you the exact time taken at any one's stage, but suffice it to say that we have a statutory time of 2 months to deal with an application, so you can say we work backwards from them. Now, there are times attached to each of these. I can't give you it right now. That could be supplied if you wish. But the intention is working with the statutory time of 2 months. You work backward to make sure that things are done within that time.
So if one submitted an outline planning request, it should really take a maximum of 2 months from my submission to your response.
Right.
Yes?
Yes, Chair.
Okay, and I'm going to take up the offer of the timelines in writing.
Yes.
Okay, so I want to know, realistically, is that 2-month time frame achieved? Because we just spoke about staffing and so. Realistically, do we achieve that? Or on an average, let's say last year, we achieved it 60%, 99.9%.
I have those figures. Take, for example, 2017. Let's, on an average, within 2 months, at East Regional Office, you would have achieved about a 45% being processed in the 2-month period. At North, around 42%. So the average is about 45% across the regional offices within the 2 months period. The larger percentage really is at the 3 month period. So on average, 42%, 42 to 45% within the 2 months. And within 3 months, another 28, roughly 28 to 30% within 3 months. More.
So that in the main, you operate outside the statutory time frame?
Yes.
And
of course, there are reasons for that, but yes.
I'm sure. I never think that is deliberate. What sort of corrective or remedial steps, because you will always have constraints, or to use a word of one of your own colleagues, creative steps are being taken to address that, that you could speak of?
Some of the things that we have done, we have encouraged people to have pre-application discussions. It's one way to speed up the time and to ensure that some issues that would come up afterwards are dealt with before, so that the applications can be processed quickly. We have set up a complex development facilitation committee that deals with large and complex matters, and that committee would comprise representatives from relevant government agencies, so that the application or the proposal could be discussed beforehand. And again, that way, when it comes in, issues that you would then have to address would be addressed beforehand. Those are two major things that we have been doing, and they have been working to a large extent. Of course, and this is future, but this future is very near, the whole trust towards devolution, that in itself should be able to help, because what is referred to as simple development, much of what takes up the time of the regional offices right now would be dealt with at the 14 municipal corporations, and that in itself should be able to deal with that. We have also been doing, and that's where we've been pushing with the whole issue of policy review and policy development, because what we have found is that sometimes, because people are not clear on the policies, both internally and the public, that in itself causes delay. So by working on that and rationalizing those policies, it helps in terms of speeding up the time. We have recently hired some more planners on contract and so on, and that also helps towards moving nearer towards the statutory time of 2 months, as the case.
And there's one question I want to carry us back to. In the discussion with Member Duki, when you spoke about constraints with enforcement, before enforcement, what I wanted to ask is, if somebody made an application for outline planning approval, do you all at all share that with the relevant regional corporation?
Normally, an outline approval is not passed on to the regional corporation. The final approval and even refusal letter, copy of the refusal letter, goes to the regional corporation. So it is shared only in the sense that if certain things are required to be done before you submit your final, that you may liaise with them, but no.
Just in terms of the outline?
No,
Okay.
the outline is not shared with
all right. So I want to ask, because enforcement is when a complaint reaches you by whatever. Would there be, and you've spoken about your constraints in staffing, I think you said there were 10. Would there be any assistance or validity in sharing with your regional corporation outline applications or outline approvals, just so that they will know proposed development is planned, and that may assist in sort of anticipating any likely breaches in light of all the constraints you may have?
Chair, that is in fact a very good suggestion and timely, because those are some of the synergies that are expected with the movement of devolving planning authority to the regional level. So that those are the kinds of synergies that, in fact, for simple development, the outline approvals will be granted by the corporation so that they would be aware. And that's one of the salient, the member asked earlier on what are some of the benefits of the bill, what can be expected, the new act. Those are some of the advantages, because now they would be the ones who would be providing the outline approval, so they definitely would be aware of what's happening.
But more in interim, because do you know when the new act will be proclaimed?
No,
okay.
I don't.
So that in the interim, so we all know that there are good plans for the future that is not too far, but we don't know when that is. So in terms of in the interim, is that something that could be pursued? Okay, and I think you said...
Yes.
You said yes, so I will turn the mic over to Member Ramras.
Thank you. I want to ask this question to planning, town and country, and local government. In November 2018, a young man called Marlon Rampasad sent me a question. It's something he's asked me on a few occasions. but he sent me an ad posted by a company called Logos Realty 868. And I'll read for you what Logos Realty 868 is advertising. It says, the ad says, "Good day and welcome to Serendipity 3, Private Estate. Let's turn your dream into an address. We want you to come and choose your lot so we can secure it for you. Lots start at $150,000 per lot, minimum 5,100 square feet. Your new home awaits you. No approvals. Electricity and water available." Now, I have seen these ads across Facebook in particular, and young people in particular tend to send it to me and say, "Minister, you know about this? I find it's a good price." And I want to ask you, what does the law say regarding the advertisement or the offer for sale of residential land without planning approval? What does the law say? And the second question is, which of you has taken action against any developer who's advertised residential land for sale in which those ads say very clearly, no town and country approval has been obtained?
In terms of the advertisement that boldly says no town country planning approval, in and of itself, that it says something about our society, that you can boldly advertise something and say it does not have town country planning permission. And then more intriguing is that you have people who will buy into it. Now, in terms of the legal aspect of whether you can take action against somebody who is advertising something that does not apply permission, I can't speak to that. I can speak to the fact that that development is therefore unauthorized. Once that comes to our attention, again, we take that as something that needs investigation. And if we can find out who well, obviously we can find out who the owners are. I can think of one case that I dealt with in Arima when that was happening. People would come in to me saying that they bought into this development, they're submitting the application, and then now we're telling them it's part of a larger parcel, the development is approved. And they would say, but the thing is advertised. And in one case, the person even told me, they were told by the vendor, if you don't buy it, somebody else will. Once we are aware of that, then it becomes a complaint and enforcement matter. I could remember that particular one. I personally opened the complaint matter. I can tell you now where things are as far as that is concerned. But once we are aware of it, we would investigate it and then take the relevant action. But you also said something. And here's where the cooperation of all agencies are important, because the person is saying there's electricity, and there's water. How could you be getting electricity and water and you don't apply permission? It's kind of strange. So it's all those things where the agencies have to work together, including the lending agency, the lending institutions. In some cases.
But just now, Ms. Dr. Kerr, the people we have before us today is tongue and country. Mm-hmm. And therefore, I think what we want to know is, what does tongue and country do? Because I think what you're saying is everybody dropping the ball. We want to know what tongue and country has done or can do or is failing to do.
Chair, as I said, what Town Country does, once we are aware of it, we would open a complaint and we treat it as unauthorized development.
Okay, let me ask you something. When somebody applies for outline planning approval and they get it,
Yes.
do you all have a database by regions of all these people who've got outline approval?
Yes, we do.
You have that. If the 13th month has passed and Mr. X got the outline planning approval, but he hasn't come back, is something done? Is an action taken by you all, or you just wait for when he comes? You assume, well, okay, he didn't have the money, not interested. Is something done by you?
Chair, that is in fact the assumption, because we wouldn't know why the person hasn't been able to implement the outline approval. In some cases, and we make allowance for that, if you cannot implement within the year, once you come before the year, then you can get an extension on the outline.
Yeah, but as if I came to you. What I'm trying to find out is, this is the 13th month. You haven't seen the person. Do you take any action? Do you write him and say, what has happened? Do you send to regional corporation and say, look, check? That's what I'm trying to find out.
No.
You just leave it up to the person to
because
come.
after the year, the outline approval has expired. So it's not really, I am even willing to say it's not incumbent on us to go to all those people who would have had an outline for a year to find out. It's actually impossible to do that. But what I can say, and this is where I take your point earlier on, and it's one of the reasons why refusals of final application are also sent to the regional corporation. So they are aware that we have refused a particular development. And I take your point in terms of letting the corporation also know that outline planning permission would have been granted in a particular case.
Member Duque.
Thank you, Madam Chair. Dr. Kirk referred to the potential synergies which are available, primarily because of the number of agencies that are involved in the process of approval. Is there currently an interagency team working together to ensure that there is unity of purpose and conformity to purpose?
If I may just ask for some clarification, when you said an interagency,
a formal team comprising, you made reference to synergies which potentially exist or may exist among the various stakeholders, government agencies involved in the process. You mentioned TNTech and WASA, and of course some of the others that are involved. Is there a formal team together, working together to ensure that there is unity of purpose, ensuring that the clear objectives are met?
The answer is yes. One is informal and one is formal. For example, at the regional corporation, and our colleagues would be able to speak to that as well, there's the coordinating committee that is at the level of the regional corporation that consists of people from all the different agencies, including Town Country, and they meet, I think it's on a monthly basis, and so we would attend those meetings to provide whatever assistance. Then at the level of the Town Country Planning Division, I spoke to the Complex Development Facilitation Committee, which we have set up as a mechanism to do just that. And we then would, when we have to deal with a particular matter, you invite members or representatives from the various agencies to deal with it. So in that sense, one is formal by way of the coordinating committee at the local government, and one is informal, which we have set up.
Let me just stick to the coordinating committee. Is it functional?
Yes, it is functional.
And the attendance and participation of the various agencies or units, would you describe it as satisfactory?
Yes, it is satisfactory, but it is triggered, in this particular committee is triggered by specific application or it may be application or proposals that developers might have. They would write indicated that they would wish to be heard, or if it comes in and we feel that it is something that requires a sitting of that committee, and in fact currently that committee is chaired by the minister herself, then we would invite representatives from the relevant agencies, and thus far it has been working, but as I said, it is triggered by some proposal which is sent or a request is made to be heard, or an application that the members of the division feel this is one that should be heard by that committee, and then we invite all relevant persons.
Okay. Members, Antoine?
Good day. Have there been instances of developers being granted final approval and completion certificates despite not receiving all statutory approvals from the relevant agencies, including the municipal corporations?
I think the regional corporation, because from the time you talk completion certificate, because the corporation would ensure that all the agencies which we have conditioned have, the applicant would have addressed those issues, and then once that is done, then completion certificate would be given. So I would probably think they might be in a position to respond here.
So let me redirect it to the municipal corporations. Are there instances of developers being granted final approval and completion certificates despite not receiving all statutory approvals from the relevant agencies?
I'll refer the question to the CEO of Shogunas.
Madam Chair, to the best of my knowledge, that will be a very and highly irregular situation. And to the best of my knowledge, I will respond to that question, no.
Of your knowledge, you would?
I will respond to the question that there's no situation, to the best of my knowledge, where developments would have been issued completion certificate by municipal corporation, well, it's Shogunas Borough Corporation, and also without having the regulatory and statutory approvals from other regulatory agencies.
Of any instances where that has taken place in other municipal corporations?
As far as I'm aware, we have no reports of such, but if any report of that nature is brought to our attention, it would definitely be investigated.
Member Simonet?
Thank you very much, Madam Chair. This question is directed to Dr. Kirk and to the other members present who may have some involvement in enforcement. Dr. Kirk, you mentioned that the enforcement division of the Town Country Planning Division is staffed by 10 contract workers. And my question firstly is that a satisfactory state of affairs given wide perception that our citizens breach the laws and sometimes enjoy the limitation having expired of 4 years for being made to answer for breaching those laws?
Chair, with your permission, I would like to allow Ms. Gisha to answer.
Good afternoon, member. In answer to your question, no, it is not a satisfactory state of affairs. The unit is currently staffed with 12 officers. And when the unit came into when it was reestablished in 2005, there was approximately 4,484 existing complaint matters. And that unit had to deal with those matters in addition to matters that would be coming on an annual basis. Up to 2016, I've had statistics which show that for each regional office, there were complaints that were submitted over 500 complaints annually. So it adds up, and we are significantly understaffed in the enforcement unit.
Thank you very much. Are you aware of any steps being taken to address that issue? That is of understaffing.
I believe the head of enforcement has made the request for additional staff.
Madam Chair, may I ask one further question? Are you aware of a policy, or is there a policy whereby, for example, the enforcement division treats with a categorization of complaints, major, minor, etc. And if there is such a categorization, or if there isn't such a categorization, ought there not to be? And would you care to, well, let me allow you to answer that question, and then I'll go to the next one.
To the best of my knowledge, and Dr. Cook may correct me, there is no categorization. We deal with complaints as they come in on a case-by-case basis.
And in relation to your own, or the division's own review and oversight, does the division take steps to itself determine whether there are infractions without there being a complaint?
Yes, the division monitors from the perspective of the development control inspectors at the regional offices who are authorized to go out and do site visits to process their applications for the planners. If they are conducting site visits and they note any infractions occurring, it is their responsibility to open a complaint with the division on behalf of the division. So from that perspective, it is not a system that is formalized, but it's based on the development control inspectors' site visit time frames, and when they go out in their particular regions, if they pick up any infractions, they report it to the enforcement unit.
Would you care to share with us whether you consider that system is an effective system that delivers a level of monitoring acceptable in these times of rapid developments throughout the country?
It is definitely not an effective system, but it is the current system that we have given the resource constraints that exist at the division.
One related question. Are you aware whether in relation to enforcement, let us say a developer who has been found to have infringed, would such a developer in any way be monitored in regard to new applications? And is there any steps taken to, as it were, impose consequences on, say, repeat offenders or persons who are developers who are known to have breached the laws in terms of town and country planning?
It is very difficult to monitor enforcement offenders, previous offenders in that manner. But that being said, I do know of some instances where the enforcement unit or members of the enforcement unit would keep an eye on certain developments. From the submission of the application perspective, if the application is submitted, for instance, on a vacant parcel, there is no way to monitor at that point what the development would look like if it will be infringed. And given the time frame for which a developer might take to complete the development. And from that instance, we usually depend on our colleagues at the regional level to monitor from their perspective the possible infringements during the implementation of the development.
Thank you very much. This final question from me, anyway, is directed to the regional corporation. Are you satisfied that you have sufficient resources in the, I think it was referred to as the building inspector or the inspector division in the corporation, to be on top of, call it, this aspect of identifying major infractions?
I would say definitely no. We have in 11 corporations, one building inspector responsible for monitoring pre-construction, post-construction, ongoing on construction based on the plans that have been submitted, together with all the enforcement matters, that one building inspector.
One building inspector for 11 corporations, or for each?
One building inspector for each of 11 corporations. Only our borough and our cities may have one or two inspectors. They may have more than one, sorry.
And is that because the current provisions are for one only, or they are unfilled of provision?
Because the current establishment is just for one, because I guess it's the year of the legislation when these establishment structures were designed. And of course, we're in the year 2019, and the population has grown, development has grown, and unfortunately, the administrative structures have not grown to keep up.
But just let me ask something, Pierce. Administrative structures will grow on their own. Can't notes be submitted somewhere for restructuring of these units?
Well,
has that been done?
Well, yes, several times, because we have been trying to reform local government for several years.
Outside of reform of local government?
Yes.
Okay?
Okay.
We see it all the time in various ministries, that people have notes for a restructure or creation of a unit. You'll hire contract workers. Isn't that a possibility within these regional corporations?
Well, that's what we have been doing, Chair. We have been creating contract positions.
And you still only have one for 11?
Well, unfortunately, we have a number, all of our chief officers, as required by our Act, they are contract officers. And it's a number, the municipal corporations came out of the county council system, where the majority of the employees there are daily paid. Subsequent to that, with the Municipal Corporation Act, they created positions at the ministry that were sent out to the corporations. Because the demand is so great, it is being done incrementally. And we are addressing those vacancies, and presently we are actually working on the structures that are required to really administer the new responsibilities and the existing. because the existing responsibilities, not only in the building inspectorate, but in terms of, other areas of the corporation's management. So we are working, we have been sending notes, we have been dealing with public administration because, there is a process to go through.
When last was a note sent for any particular corporation?
Just recently, we did for some of the offices.
Give me, in writing, the date, because it might be difficult to have that in your head.
Yeah.
And the last time there's been a follow-up on that note. If you could give me that, I'll be happy.
Sure.
Let me ask one question before I let Member Andrine come in. Is there a difference in the qualifications for an engineer, distinct from a building inspector? Because, for instance, Port of Spain City Corporation has a city engineer.
Yeah.
So in the other regional corporations, and I'm using the word regional to distinguish it from city and borough, so I'm not using municipal. Is there a post for an engineer? And whether there's a difference in the qualification between a building inspector and an engineer?
Good afternoon, esteemed members. I'm from the Port of Spain City Corporation. At the Port of Spain Corporation, we have an assistant city engineer, a city engineer that heads our building section, which houses the building inspectorate. The city engineer, according to the requirements, is supposed to be a registered engineer, board registered with the Board of Engineering of Trinidad and Tobago. The assistant city engineer also has to hold that qualification. The building inspectorate, they are technical officers that would have done technical courses at, say, John D. or UTT and so on, and then would have, through experience, come up that rank in terms of...
But they would not have the professional designation of engineer?
That's corr't.
Okay. So as far as the municipal corporations, and this is really directed now to the permanent secretary, we keep talking about the new dispensation. Would the municipal corporations, and let's say the regional corporations, be equipped and staffed to carry out this responsibility you all have in monitoring buildings?
Chair, that's what we have a transformation committee working on presently in terms of ensuring that the corporations do have the resources that is required to take on the additional responsibilities. In the meantime, we are trying to train up the persons that we do have, especially in areas of procurement, because of the procurement legislation, because it's not only the planning and facilitation of development bill we have to prepare for, but a number of initiatives in the wider public sector. So we are working with public administration, and we have a technical committee set up to look at the existing processes and systems towards re-engineering what we consider redundant or inefficient, to ensure that what we do when we establish our new corporations, that it would be not bringing into the old things that doesn't work into the new system. So that's part of what is happening at the ministry.
Thank you. Member Antwine.
I just want to follow up on some of the questions from Member Simonet. What is the investigative capacity of the staff of the enforcement unit?
Currently, the enforcement unit is staffed with 1 enforcement supervisor, 3 enforcement officers, 2 8 enforcement officer 1s, and the enforcement supervisor oversees the enforcement officer 1s and 2s in carrying out their investigative duties. They would have received training from the enforcement supervisor under Section 16(1) of the Town and Country Planning Act, which describes how to carry out enforcement activities.
So you have no specialist investigators?
No, just contract officers that were hired for the purpose. And they are assisted by the legal unit at the ministry.
What types of enforcement action can be taken by Town and Country Division? For instance, demolition of structures and so forth. What type of enforcement action is taken?
If a matter proceeds to enforcement stage, the offender can be taken to court and fined, and demolition can also take place under the Act. So far, we've been mainly proceeding through the courts.
But if somebody constructs an illegal structure, can it be? Yeah.
It goes through the enforcement process, which ultimately leads to a court hearing.
What's the time frame for the completion of that?
Well, it varies depending on information that we have to receive. We have to obtain from the offenders legal searches that we may have to do, but we try not to let enforcement matters remain pending for more than 4 years, because after that it becomes statute barred.
And if it becomes statute barred, what happens?
The division can no longer enforce on the matter.
That's if it's in court?
No, if it's in court, it's an ongoing matter. If 4 years have passed without the division taking action on the matter, it becomes statute barred. So
in 2018, how many statute barred matters you all have?
No, I don't have that information before me. I can get it for you. I just have the amount of complaints submitted.
Yeah, could we get that, please?
Okay, sure.
What is the level of fine? The process that you all have preferred. What is the maximum fine in the court process?
I can't give that information either. I'll have to ask the legal unit, but I believe it's...
Maybe the PS could assist from the submission.
Sure.
I myself am out on this information, but I know it is a percentage, and it could be substantial over time, because I think it is. Is it every year?
It's daily.
It's daily.
Mr. Pierce, you would have signed this submission, correct? Or you would have seen this? I'm almost certain, but if I get the time, I saw $150 a day in the submission. I didn't see a percentage, but I will allow Member Rambarat to ask his question in the meantime, and I'll see if I find it in the submission. Member Rambarat.
To the two permanent secretaries. Going back to the question I asked earlier. Now, I referred to the serendipity tree development. All that was advertised was a survey plan, unsigned survey plan, which is typical of these types of operations. There are 50 lots, and the lots are advertised for $150,000. It means that I estimate this development will utilize about 10 acres of land, and the developer will pocket $7.5 million. But the people who have bought into this development will not have the benefit of garbage collection. They would not have the benefit of postal services. The people who have to plan for resource allocation in the country will not plan for additional school spaces. The health authorities will not plan for the health needs of these communities. The issues of structural integrity and preparation for flooding and all those things would not have been addressed. So there are 11 public officers before us today, including 2 permanent secretaries. I want to know from you, what are you doing to protect the public in this country, the public interest? In August 2018, a young lady called Alison Jackman from Enterprise in Chaguanas sent me an ad for a development in Grand Couva. She was very excited because it said, excellent views of the Central Range. What would happen to her? Taking her hard-earned money to buy into a development for which there are no approvals. And Section 16 of the Town and Country Planning Act and the rest of Part 3 is very clear. You have very clear authority for any development in this country that does not have the requisite planning approval, including, if you take action, if you trigger Section 13 of the Act, at a minimum, you'll have the opportunity to eventually charge the developer $300 a day. So my question to you, PS, is, what have you done in the last 5 years to protect the public's interests against land developers, residential land developers, who advertise residential lots for sale without town and country planning approval? That's the first question. And the second question, after today, what do you intend to do to bring to the attention of the public the fact that this is a pervasive problem in this country, and to advise them of the risks of buying into developments for which there is no approval?
You want to talk first? Go ahead. Chair, through you, Chair, I would like to. She's not ready. Oh, I saw she's not ready. Okay. I would like to refer the question to our CEO of Chaguanas, and for one particular reason. They would explain the challenges they have in enforcing matters at the regional corporations. And the other matter I'd like to address is the issue of advertisement and offer of sale. Our present legislation doesn't make any provisions for us to take action against anybody advertising or offering for sale land for development. But if it is brought to our attention, we do have the authority under the Municipal Corporation Act to take enforcement proceedings once development starts on the ground. To explain what the challenges are in actually taking action, I would ask those who are operating on the ground, as they would be better able to explain the process and the issues related to the process. Thank you.
Madam Chair, I have no doubt in my mind that the municipal corporations are empowered to deal with unauthorized structures. And the local authority comes into the picture basically when a structure or the sub-engineering works has commenced. The process requires basically that the matter be brought to the corporation, an investigation is undertaken by the Building Inspectorate Department, and based on the breaches, the recommendations of the Building Inspectorate Department, either they make recommendations to serve a letter of advice or an enforcement statutory show cause notice. The law also provides, to the best of my knowledge, that the person who is deemed to be in breach can be called before the council to show sufficient cause as to why it is the structure should not be removed, pulled down, or altered. However, corporations, to the best of my knowledge, and some of them that I would have worked in, err on the side of caution rather than enforcing their authority to demolish. They take the position sometimes that they prefer to go and seek a determination of the court at summary level. So that in itself sometimes is a tardy and lengthy process, and the fact that the engineers sometimes are on the corporation or contract, you find situations where the engineers are no longer with the corporation to represent the corporation and lead evidence in the matter, and sometimes these matters get dismissed. Yes, but the enforcement process after the enforcement notice, of course, requires that the notice, according to 163 of the Act, to the best of my knowledge, it requires that the notice, the statutory notice, be served by council. That in itself means and is interpreted that before you can enforce the notice to serve, then you need to bring it to the council. And the council is defined basically as the local authority. So what happens is that the process is a bit challenging at the level of the corporation to enforce. But also, I would want to admit to this committee, because the mandate of this committee is to make recommendations for improvement, that the enforcement is tardy, because sometimes you find reports go to council, and sometimes no action is taken, no decision is taken, and the matter remains in abeyance. We all will probably recall and know that enforcement of structures in the decision of the local authority, sometimes they're a bit reluctant, and they consider what is deemed to be sufficient cause. To the best of my knowledge, for a person who is deemed to be in breach, to show sufficient cause means to me that you will show why it is or how it is your unauthorized structure could be brought in accordance with the law, probably by removing some offending portion or making some kind of arrangement. But you find situations sometimes where people give all kind of reasons that we poor and we're trying to make a living and we do things, we didn't know. And these things just get left behind, no decisions are made, and you find enforcement remains in abeyance. Of course, the law will specify a period of time for enforcement after the information comes to your knowledge. I think it will be 6 months. I subject to be correction. I mean, I can just read the law. I can't interpret it. But I think it is 6 months. And when this goes on, and then sometimes corporations serve notice, and then nothing happens, and then you serve notice again, it is deemed to be an abuse of process. And as a result of that, you have difficulty in enforcement. The point I want to make to the committee also is that coming out of the discussion, I would like to see in our country that we have what is called a municipal court, to deal with issues specifically with municipal challenges and enforcement and breaches. These matters go to our normal judiciary system, and it gets inside there, and it is postponed, and I can recall in Princeton a matter of a simple blocking of a drain probably would have gone on for over a year and a half, 2 years, and I probably leave that corporation and didn't know what was the determination of the matter. But at the corporation, really and truly, you have challenges with enforcement. Yes, they have the power to enforce, but they tend to err on the side of caution. The second part of the question that deals with, after today, what do you intend to do to bring this kind of information to the people? I would want to see, as a local authority, if this information should come to the local authority, we should have an obligation at least to put an advertisement on the papers informing the public that our records do not show that an approval was granted. And people should err on the side of caution to ensure that if they invest in these developments, they have the responsibility to take steps to be advised that the title is in fact marketable and free from encumbrances. So, and in addition to that, I would think the corporations can either put on their social media, their web pages, or on their Facebook account, so that people can have access to the information, rather than having to come to the corporation to ask and inquire whether these developments benefited from the approval of the local authority. So I hope I would have answered your question.
And certainly putting it on their webpage costs no money. Because the issue, I'm sure if we said about ads, there would have been a question about constrained financial resources. Thank you. You have a question? Okay. Between Town and Country Planning Division and EMA in terms of your land use policy and in terms of your given final approval for developments?
Yes, Chair, there is a relationship in that once based on the EMA Act, there are certain activities or development that would be referred to as designated activities. And once those things are flagged, when an application is made, the applicant would be so advised that they would need to provide correspondence from the EMA that would tell us that an EIA is not required. You see, once it falls within the designated activity, the EMA is the one who would be able to say to that applicant, you require a CEC, or as part of that CEC, you need to do an EIA. So in that way, we are working with the EMA as far as that is concerned. As a matter of fact, as recent as last week, we met with the EMA to, again, iron out some of the issues that come up from time to time in terms of people submitting applications to us, and at the same time, or they may not submit an application to us, but they submit for a CEC. So we met as recent as last week, and my colleague, Ms. Fortune Rollock, would have been there, and she is now awaiting clarification in terms of what was agreed, so that will now become directive to all members of staff. Then secondly, again, as a result of collaboration with the EMA, there's the problem when the EMA would have been entering into negotiation with persons who would have infringed, and so they were working with them with what they need to do. But what they found out eventually was that these people may have infringed and they might be able to do certain things to correct what they did, but they wouldn't get Town and Country approval. So again, having met with them, with the legal persons and so on, we came up with a procedure whereby they know once they flag something would send it to us so that we would investigate and make sure whether or not it fits into the land use, so that they could then know how to proceed. So those are two ways that I can tell you up front that we have been working with the EMA, and it's even better now because they're under the same ministry, so as to sort of streamline the activities between the Town and Country Planning Division and the EMA as it relates to the approval process.
Let me ask something. Do you, and this might be either to the PS local government or to the PS of Town and Country Planning, do you think that there may exist certain blurring of the areas of responsibilities amongst the various agencies that may affect their ability to discharge their mandates. So when you look at EMA, when you look at the municipal corporations, when you look at town and country.
When we look at some of the activities, I don't really see an issue of blurring. I mean, town country has certain activities and certain procedures. EMA has certain things that they do in terms of CEC and all of these things. There is, as Dr. Cook indicated, there is this sort of relationship that we have, and we're also under one ministry. So I don't really see too much of the blurring as such.
But doesn't one impact on the other?
Yes, it does.
Okay, so that Dr. Kirk is now telling us about something that is evolving. Mm-hmm. And I'm asking if prior to now, if either it's because there's a blurring or maybe it's because there are silos that, you know, the benefit to Trinidad and Tobago is not being derived.
Dr. Cook,
Just to add to what the PS was saying, Chair, and the answer is yes. And that, as I said, in terms of the recent meeting we had with them, it was an expression of some of that, so that the Town Country Planning Division deals with land use, so that if you're submitting a proposal, then you by law, you submit it to the Town Country Planning Division. The EMA has responsibility for granting CEC for certain designated activities. And so some people have, in fact, been going to the EMA even before coming to Town Country Planning Division, because they would see the EMA as being responsible for environmental matters and so on, and granting the CEC. But one impacts the other. The land use is about in the environment. So that what we found, therefore, is an example of what you're saying. There at times appeared to be a blurring of the responsibilities. For example, at one time, EIAs and so on were approved by Town Country Planning Division before the EMA Act. So it's almost like there are some issues that would come up and need to be rationalized or fleshed out and streamlined. And this is what we're discovering, and the discussions, as I said, that we've been having with them as recent as last week is in fact to deal with some of those issues. So the answer is yes, and when they come up, like as we have been seeing now, we would work with them to sort of streamline those situations.
Okay, let me ask something to the Town and Country Planning Division. Are you in a position to say, let's say in the last 5 years, how many applications you got under Section 14 of your Act? That's the provision that deals with retention.
No.
Do you track that?
The information can be made available, but I wouldn't have it here now.
Okay.
But yes, that can be done.
Mm-hmm. Is there too much reliance on the fact that people could come to, want to have a better word, regularize? Is there too much reliance by the Town and Country Planning Division on that facility that seems to affect a sort of more, and I don't want to use the word aggressive, but maybe a more forceful approach to enforcement?
Chair, I don't know that there is a reliance on preferring to deal with retention. In fact, it's not something that I've ever heard discussed that you would prefer that, and I don't know if subconsciously that is thinking. We would always prefer if you submit your development proposal before you do anything. Okay. It's less headache. It's the thing that we would prefer, so that I would answer no, okay, that there isn't a reliance on, retention.
On okay, so let me ask then something else. I am looking at your submission under enforcement, okay? And it appears to me that there is a built-in, through every step, there's a built-in mechanism, or a built-in delay to allow one, and I would use the word to regularize, because if you have breached, because that's when you reach enforcement, you have breached. So you have a 28-day period where you have to comply. Then you have a 56-day period. So it appears to me that it seems to be built in to the whole approach, an ability to regularize your process.
Chair, and I would stand corrected, but I think some of these things are in fact legal requirements. So it's not that we necessarily just arbitrarily give a day. I think some of these, in fact, the days here, I am almost certain they apply based on the law. That persons would be given X amount of time to do X. So it's not so much that we rely on this as the way to go. As I said, we would much prefer not to have to be dealing with enforcement. Enforcement is not...
And Dr. Kerr, I don't think we really deal with enforcement, because we talk about lack of resources. And, so that, when the assistant director spoke about, I think it was the 2014 figure, and 500 applications per year, or
complaints,
breaches per year, per region. And I think it's 4 regional offices you all have. So that's 2,000 a year. Okay? I don't know that we're really talking enforcement here.
Chair, well, by the mere statistics, you may be right. So I will not argue with you on that, but it's not for want of trying.
The statistics I got are yours.
Sorry?
The statistics I got are yours. And therefore, and that's the point. I think what we're trying to look at is, rather than reaching enforcement, how do we use the limited resources we have to almost be preemptory? I think that is what we're trying to find, a mechanism, because we recognize you don't have, or you recognize, as you've told us repeatedly, you don't have the resources for enforcement. But there are certain sister agencies. There are certain existing mechanisms, okay, that you've outlined. I thought when you first started talking about the coordinating committee, you were talking about the coordinating committee resident in each of the regional corporations. And I think that is why Member Duki may have asked the questions he asked. But then I realized that you're talking about a different type of coordinating committee. But even within your sister agencies, there are structures that exist. And why then doesn't one take advantage of those? You may not ever catch all, but you may catch some before they even reach to the stage. Why aren't we using those? Or why can't we create some more of these committees? You don't need statute for that, to assist us in dealing with an issue that we know when it reaches enforcement, we can't deal with at all. And I guess this is what we're trying to find out. How do we collectively put our heads together? We've brought a very experienced CEO, it would appear, from Shogunas Borough. Why can't we then get out of our silos and look at and meet and treat with things. We have your deputy PS talking about creative mechanisms that one uses for getting public views on your policies. What about in terms of you all being informed of things beforehand? How do we deal with that?
You can go ahead.
Chair, I was really hoping that you would get to the point of the positive things and the positive initiatives, understanding and appreciating all of the challenges that members of the public, I'm sure, are well aware of because they feel the pain daily, and members here as well. So we are accepting that it is less than the most efficient of processes. So at this point, a number of initiatives have taken that into consideration, and I think it would be appropriate for those persons to share a bit. I would say, though, in context, there is an admittance at the level of Town and Country Planning Division of the Ministry of Planning and Development that for years we seem to have been terrified to speak to the public. You see, when we go to the public, they start to ask us questions like, so why my application is taking so long? And it sort of kills your attempt to go any further. But there have been several attempts, and we have a very good relationship with some of the financial agencies and so, who would call us out to various days where we share with members of the public appropriate actions, appropriate activities, and to give them some sight of not falling prey to some of the things that members spoke about earlier. Now, to my knowledge, and I can be corrected because I'm by no way a legal mind, putting up an ad there, you have not broken the law. Because of our existing legislation, you've done nothing really. And I remember as we talk about creative strategies years ago, now I'm not saying this, I'm just saying something that happened years ago. Years ago, when the problem of vending on the highways in particular was out of control, and you would see police pulling up and running the vendors and all of that, the police started to charge people who stopped. And then I noticed, so it is painful because you are the victim as somebody's offering you something and you buy into it. So what the police were saying, that it's your responsibility to know that you cannot stop here to purchase oranges or anything that's being sold. I'm not in the least being or recommending any draconian measures, but what I am saying is that it is our responsibility, collectively, all the people you sitting here, to spread the word as to what is allowed and what is not right. So maybe we can't get the people who put on their webpage that, here, come, buy into our beautiful sites. But we can tell you what you can't and can't do, and we intend to do more of that. So there are 3 initiatives currently taking place at the division. And one of those initiatives entails, because I've seen the little videos and ads that the staff have willingly done already, to put it out there in social media. Yes, we wish we had the resources to put it out there, like on the news, but you know how costly that is. So we're okay with social media for the time being. And I would like, if I may do so through my PS, to even invite, I know there are others who are in the back row, who could speak of some of the initiatives that will address, in particular, something you brought our attention to, the issue of possible blurring of boundaries and the challenges of coordination. Actually, the automation project has forced us all to work together, and we are discovering challenges along the way. So there is something in place to begin to address that, as well as other things. So rather than end these sessions with people probably being in tears and thinking there is no hope, I would hope that we have the opportunity to share some positive things, Chair, if that's all right with you.
Thank you so much for seizing the opportunity. I just want to ask one thing. In addressing all these things, if we could have an idea of timelines for these deliveries on these projects. Thank you.
Good afternoon, Chair, members. I will say a bit about the automation of the construction permitting system project that we are undertaking. So at the Town and Country Planning Division, I think we all know all of the challenges that we have faced, the complaints that we've had from members of the public. So over the last year and a half, we've been working with the Ministry of Trade to automate the process, not just at Town and Country, but actually working with all the other agencies involved in the process. So in addition to automating fully Town and Country's application processes, we are also automating fully the processes at the municipal corporation, and also including portals and windows to some of the other agencies like fire services, WASA, Highways Division, Drainage Division. I think at last count, there are about 20 other agencies involved in the process to ensure that we all have, I guess, an online one-stop shop for everybody to give their approvals. But in addition to the approval side of things, there are two key things I think we are trying to implement in the project that will maybe give a little bit of relief to the public. One is the facility to submit complaints through that online system. So if you notice there's an infringement, you don't need to log in, you don't need to register. You just need to fill in your name, your details, information about the complaint and where you observed it. And then our officers, our enforcement unit will take that up and begin the investigative process. Another facility that we are building into that system is the ability for anybody in the country to go onto the online system. Again, no login, no registration. And you can actually see what applications have been approved or submitted at the Town and Country Planning Division. So you can see whether you are in Rio Claro, you can see if your neighbor next door has submitted something. If you are in Port of Spain, you can see what are the types of developments that may be coming up in the system and whether it has been approved or rejected. So that's just a bit about what automation hopes to achieve. I will go back to the approval side of things though. We really hope that with the collaboration that we've had to date with the different agencies, then we can see not only time improvements, but also improvements to some of the obscurity and inefficiencies that we've noticed. Particularly, we found that a lot of agencies aren't actually sure about the rules of other agencies. So those are some of the issues and the criteria for referring things to other agencies. Those are just some of the things that we are trying to address through the project. You mentioned that you want to hear some timelines, so we are pretty advanced in the project. We're still in the software development stage, but we're actually hoping that by the end of this month, by the beginning of March, we'll have a final system that we can take to these agencies and begin the user testing. User testing is actually looking in detail, make sure all the functionalities that the different agencies need are designed into the system before we begin a pilot of that system. So we're expecting by the end of April, the beginning of May, we'll actually have a system to pilot in Port of Spain before we begin national rollout later on this year.
So, just let me ask, we have cabinet approval for that, and we have the funding?
Yes.
Yes? So you say by the end of this year?
Yes.
I'm sure the public is very happy to hear that. So whatever other good news you will have to share with the public. Let me ask one thing before you go. In terms of if I had a complaint that I was living in a residential area and somebody started a spray painting garage next door, to whom do I make that complaint? And who deals with it effectively?
Currently or in the automated system?
Currently, and you'll tell me how you treat with it in the automated after. Currently?
Currently, you need to submit a complaint to Town and Country. You can go into one of our 4 regional offices or contact our head office. There are officers at each of those offices who will guide persons, tell them that you need to maybe give us a picture or you need to describe what the issue is, and we will also take their contact details, and then they open the complaint matter and begin the investigation.
Okay, but what about anonymity? I come, I tell you I live in next door, I could give you the address. Don't you have officers that go and inspect?
Yes.
Why do I need to bring pictures?
You don't necessarily need to bring pictures, but it's helpful for us.
It's helpful for you.
Yes.
How many officers in each of these regional? I think Ms. Gishad, I think you had told us about these site visits, but I can't remember if you told us the number of officers per region, and I don't think you told us how frequently they do site visits and how are the regions allocated in terms divided up among the officers, because we could have officers, but the district's so big, they get there once in 3 years.
That is actually, well, they don't get there once in 3 years, but you are accurate in stating that the regions are fairly large and the officers have to sort of share various regions, more than one per officer. So currently in each regional office, there are posts for 5 development control inspectors. They visit on a weekly. Currently, in the South Regional Office, the posts are filled, uncertain with the North Regional Office, and in the East, they are filled as well. But that's recently. They've all been filled. The officers do their site visits on a weekly basis. In some offices, because of the volume of applications submitted, they're required to do site visits twice per week just to keep up with the volume of work. South Regional Office, for instance, has purview over approximately 8 regional corporations. So, and it's divided into 3 large regions, and those regions are further divided into sub-regions. An officer may be responsible for approximately 3 or 4 sub-regions, and by sub-region, I mean, for instance, one officer may have to visit Point Fortin, Cedrus, Icarcus, and Barrackpore, and they have to get those files done on a weekly basis because applications come in bulk daily. Was that clear? Is there any more information about the site visits you required? Yeah. Thanks. Yeah.
In terms of, let's say, complaints made, site visits being done by one of your officers, then what happens, ideally?
Those site visits I spoke about were with respect to the development control inspectors. Yeah. So those are the ones that receive applications. The enforcement unit, they also go out, the officers also go out on a weekly basis, sometimes the same sort of process bi-weekly. And there is currently 2 enforcement officers. There are 2 enforcement officers assigned to each regional office with assistance from contract officers like OJTs or GPAs. As the complaint is submitted, they do research, they pull records from the vault at Town and Country to ensure that there has been no approvals for the development, any sort of applications that may have been submitted on the site, and then they conduct their site visits where they take pictures.
Okay, let me just ask you one
Sure.
thing. So if I'm living in a residential area, the example I've given,
Yeah.
somebody opens a garage next door, with spray painting and so on.
Yes.
For Town and Country to give the approval, because you see they'll pull records. If they had given approval, isn't any sort of investigation done before they give approval?
Right.
Wouldn't neighbors in the area be interviewed or anything like that? Wouldn't EMA would have been consulted by Town and Country for an approval?
Yes, yes to all of those things that you've said.
Yes.
There are some instances where Town and Country may give a notice of refusal to such a development, and the option is then given to the applicant to appeal that decision through the advisory town planning panel process, and that panel listens to the applicant's perspective and may make a recommendation to the minister based on other humanitarian grounds, possibly, to approve the development. And there are instances where a development might be approved based on a grant of ministerial relief.
Would I know as a neighbor, would my neighborhood know that there's no approved auto body spray painter allowed in our neighborhood?
If the neighbor has made the complaint, and through the research of the enforcement officer, we find that a grant of ministerial relief has been granted and the development is in fact approved, a letter would go to the complainant, indicating that the matter will no longer be pursued by Town and Country.
Yeah, but what I'm saying is, I am not the neighbor that made the complaint.
Okay.
I am living on a street, 15 houses. There is a process, from what you explained to me, if somebody, number 12, is now going to change his house into an auto spray painting garage. Am I, number 10, my views are they first ascertained with respect to this process? Number 11, paid no attention. Is he notified at the end of the process? Because he lives on the street. He's going to be impacted. Am I, number 11, notified that a development of an auto spray painting garage is now permissible on my street?
If Town and Country is considering granting an approval, then there's a process where attitudinal survey is carried out amongst the neighboring residents as to whether they object, what are their concerns, and that is brought back to the division. But however, if Town and Country issues a notice of refusal and it goes through the relief process, there is a chance that that ministerial relief may be granted without any sort of surveys being carried out of the opinions and concerns of the neighboring residents.
What about EMA concerns?
Once it falls under the designated activity.
No, that's why I specifically asked. The example I gave is a specific kind of example.
Yes, EMA.
I mightn't want it. I mightn't want a auto spray painting garage because of whatever my fancy is. But there may be medical and environmental issues as a result. So I'm trying with a specific example to capture both things.
I believe the public health department is a part of that process. Town and Country would seek some form of some conversation with the public health would occur in addition to the attitudinal survey. I'm not sure. Depending on the scale of the development, then the EMA would be brought on. We would request information from the applicant as to whether they have received approval from the EMA.
Chair,
Yes.
if with your permission, could I just add, and that's one of the things that we sat with the EMA and worked out, in that that particular example is an infringement of the Act. And so what has happened is that people would also make complaints to the EMA. What we have arranged with the EMA is those complaints, when they come in, they do initial investigation, and once it's definitely unauthorized development, they forward it to us, so that we are working together with the EMA as far as those matters are concerned. And that's an example of how we are now handling that.
Let me ask another example, and maybe this now is the collaboration between the municipal corporations and the Town and Country. So I'm living in a street, all single-family units. Somebody goes and they construct 4, 5 levels, and it now becomes a multi-residential user. Okay? Where does my complaint lie? To the municipal corporation or to the Town and Country?
To both, Chair. You can lodge a complaint at the Town and Country Planning Division as well as at the regional corporation. So it's to both.
Who takes the lead? Because what will be the experience with people is they would say, they'll go to regional corporation, they'll say, no, we don't have power, go to Town and Country. Town and Country would say, no, go to regional corporation. Who takes the lead?
Chair, once a matter comes to us, whether or not the regional corporation is involved. In fact, what we do sometimes, we
Dr.
advise
Kirk,
them.
let me just say this, not to cut you. We're on TV.
Yes.
And you see, I just told people about Twitter and PAL and so on. So sometimes let's be careful, because then all the devices here start to light up.
It doesn't change my response, Chair, because I'm saying that if it comes to us, we begin the process. We would not know if they would have gone to the corporation. We, however, actually tell people you can also make your complaints with the corporation. In fact, we sometimes say to people, they can even act faster than we can. In terms of the procedure then becomes a court.
And that's suppose what I say, I go to you, you tell me go to them. I go to them, they tell me go back to you.
We don't ignore it, but we also inform them that action could be taken there. It's not that we're not pursuing the matter. We're also saying to you, you have reinforcement. You can also go to the corporation. So I'm not saying that we don't deal with it. We do deal with it, but we also advise them. You can also get assistance from the corporation.
I can pursue both limbs
at the same time.
Simultaneously.
At the same, yes.
And I could get redress from both limbs simultaneously. That's what you're saying?
Yes.
So you could carry the person to court, and so can the municipal corporation carry them to court at the same time?
Well, they can advise in terms of, because they can issue a stop.
I asked a specific question.
And my answer is because I may not be as versed in their act and their law. That's why I'm saying they might be able to better answer there. I know what we can do. And so I'm saying that's what I was just going to say. Probably the corporation might be able to say, based on their act, they can still pursue whilst we are doing it. I would not be able to say yes at this point in time, so that's why I was deferring to them there.
Yes, Madam Pierce.
Yes.
I'll refer to the building inspector.
Right. So yes, the answer is yes, that the action can be taken simultaneously by both organizations, and the municipal corporation will act under the Municipal Corporations Act, and there are provisions in there for change of use, additions, new buildings, and it doesn't impinge on what town and country planning may be contemplating in terms of their action.
Can I ask why we haven't seen more of that? Because when the two finds add up, it might make a little more sense. Why haven't we seen more of that?
On the question of enforcement, aside from saying that, well, there are other challenges in terms of taking action, and it's really a willpower by some of the regional corporations in how they treat with some of these matters. The coverage of the areas by some of the inspectors and so on. So if you could look at probably the statistics of notices served and as compared to action taken in terms of enforcement. And from time to time, you would see some regional corporations actually putting ads in the papers as to what properties they would be, that have been earmarked for demolition and so on. So that some of the regional corporations would have taken very affirmative action towards enforcement and putting that out to the public that it's going to be demolished. And some of them have, in fact, actually carried out demolitions.
Thank you, Member Antwine.
I want just to take a slight variation. This is about a business or a neighbor makes an addition or alteration to their building. For instance, they take up the pedestrian area, build the building right up to the curb. Now the pedestrians have to walk into the street instead of using the walkway. Or a neighbor extends his fence and cuts off the neighbor's drain so that they can no longer, the water no longer have access to go to the neighbor drain. Or the neighbor builds a drain and the water now floods your property. What recourse do the citizens have in terms of town and country and the municipal corporation to get some relief?
Okay, at the municipal corporations, they also encompass the public health department. So in some cases, it's a two-pronged approach, even at the regional corporations and municipal corporations, where things like blockage of drain will come under the public health ordinance in terms of their action. And those are things most of the regional corporations will take seriously in terms of drainage issues and so on. Some of the regional corporations, the way they have tend to focus not really what is prescribed in the Municipal Corporations Act, because the Municipal Corporations Act is clear under Section 163 as a process to deal with illegal structures. Some of them have chosen to want to go the route of the law to say that you want to charge a fine, and that's where it gets bogged down in this whole scenario of going to court and filing a complaint and so on. But the municipal corporation does prescribe an action for demolition.
If a situation takes place where the residents written to the municipal corporation, town and country planning, even to the police, even to the member of parliament, and no action is taken, what recourse is left for them?
Okay, that's not a fair question to ask. All right, that question I think is just really a comment, okay? But I just want to switch the conversation a bit and to go back to where Ms. Hines had invited us, and that was the good stories. We had one good story, which was the automated system and process that we expect by the end of this year. I think there were some other good stories that you wanted to share with us and the public. And therefore, I ask that we identify the next good story and share that.
One of the things that you mentioned, Chair, quite rightly so, when you spoke about it is possible that the people in a community may not even know what development is coming their way, because the current system does not readily share that information with an ordinary man on the street. Of course, we have public registers under the Town and Country Planning Act, and you can come into any office and you can inquire. But I am excited by the new legislation, which mandates third-party rights almost. It's got to be put out there in the public domain that a development is coming. We see it with large developments. I mean, if something is happening in Trinidad City, you might see a big sign goes up and shows you what the drawing may look like. But under the new legislation, it is mandated that that information be put out there. One very positive thing is the conversations that have already begun. The PS of local development. Yes, the PS mentioned that on their end they have a transformation committee, and it mirrors what we are doing in the Ministry of Planning as well. And the conversations have begun, and there are upcoming meetings, as a matter of fact, that even the ministers are meeting to discuss what actually is required to ensure that when we proclaim a much more efficient system is the end result. So for me, it's very positive that we continue to identify the loops and the gaps to be able to ensure that a much more public-friendly system is put in place. I sat on a committee, on a task force that looked at local government reform. And it's relevant even now. And one of the things recommended at that point in time was that within the space of the corporation, there is such a thing as a public inquiry. You see it abroad, you see it in other places, where any new development in this space have got to come before council. It's made public so everybody gets a chance. So in addition to just a billboard going up, it becomes clear in a community, this is a plan for this site. It's put out there in the public domain, and everybody gets the opportunity to speak into it and possibly even vote on it. Those were the kinds of things that were actually written in for further conversation in the local government reform. So when we continue to meet together, it would be a fleshing out of what institutional framework do we actually put in place to improve our service delivery to members of the public. So that gave me great hope. In addition to that, there are, yes, current things happening. There's a project we call Improving the Service Delivery Infrastructure at Town and Country Planning Division. And that project is an acknowledgement that, there are two clientele that are served through the Town and Country Planning Division. It's members of the public, but it's also their internal clientele. There's an appreciation that it's a very stressful job and that you've got to improve the working environment of the people working in the midst of working in the deep, deep, deep dungeon. We call some of these places black holes. But there's also an appreciation that the members of the public deserve so much more. So we are working on things like, it may sound simple or even petty, but it's important when you come up with a service charter, which is an agreement that this is how we are going to serve you. These are the time frames we want to respect. That's your responsibility, and this is ours. And we've literally just completed an acceptable review of that, and it is going to go out there. So you're going to be hearing, and members of the public will be hearing of focus groups. We've done some in the past where we pulled in many of the developers that we know. We sat them down and we told them, tell us what is your pain. And it is that kind of collaboration, and we did it with the staff as well, that resulted in us coming up with a few suggestions as things we could try to implement now, together with automation, together with the digitization of our records. Because you can appreciate how frustrating it is. That's part of the reason why the team here said things take so long. For us to work efficiently, you have to have the records that speak to what was done in the past. Just picture thousands of paper records. And a lot is dependent upon the memory, the institutional memory of some of the really senior officers who left and kept coming back to help us. So we are trying to tackle the problem of service delivery on many ends, many approaches. It's a start. We're not going to hide and pretend that it's not been difficult and the members of the public have not really gotten the best. But the final very positive thing to me, it's when we put out there, some of the things are not out there yet, but we are committed to telling people the benefits of having planning permission. And I choose to use the word benefit, because we're not always there only to torment you and to keep you in pain. It's really a benefit to know what you can do, what you can't do, and the best way in which you could develop the space that's available to you. So I will stop speaking at this point and defer to the Director of Town and Country, who may have other things he might want to share.
You've done a very good job, DPS, because those were some of the additional things we would have wanted to let you know, Chair, that that have been happening. And in the midst of all the constraints and everything else, we haven't given up hope. I mean, right now you have had, given all the financial constraints, people actually put their hand in their pocket and buying paper and stamps and so on to serve the public. So in light of all of those constraints, we are still doing the things that would improve, as we said, the service delivery project, the digitization. And earlier on, when I was talking about the impending proclamation, I might seem to be pretty much on that because it represents an amendment and an addressing of some of the issues that we have been dealing with in the past through the new act. Ms. Hines would have mentioned, and that was one of them, when the member was talking about people not knowing, or yourself, Chair, what's happening in the neighborhood. Some of the things that will now have to happen when you are proposing a development, you have to put it up on a board that says this is what is going to be coming. So some things we cannot fully address right now, but we trust that in the near future, because of the new act. I mean, this is 50 years we're operating with the current act, and we're hoping that that will add to some improvement in some of the things. So those are good news items that we would also like to put out there.
Thank you very much. Member Duki? Oh, Member Simonetz. Member Simonetz, sorry.
Thank you very much, Madam Chair. I would certainly like to acknowledge that the good things are good to hear, and that we certainly encourage you to continue in that vein. Permit me, however, to return to the issue, or rather the matter of Greenvale. Certain questions were asked in the Senate, I believe, on Tuesday, and certain answers were given, I believe, provided with the assistance of Town and Country Planning Division. I simply would like to ask the following questions, please, in relation to that matter. Has the draft East-West Corridor Land Use Strategy Plan been finalized?
I am not clear as to which draft plan you're referring to, member.
I believe earlier in the proceedings, it was shared with us that land use plans, and I think it's in your document as well, are prepared by the Town and Country Planning Division, and that is done in regions or sections of the country. And I was simply wondering whether there is such a plan, whether in draft or final, for the East-West corridor.
Currently, there isn't any for the East-West corridor. What we're doing in the East-West corridor is that we are consolidating the existing land use plans. We are tackling them by area so that we're going through from Port of Spain. So that's the nearest thing to East-West, but it's not being tackled as the East-West. We are consolidating the existing plans. So, for example, we are looking at, there's a plan for Tunapuna, there's a plan for Kurep, and so we are taking each one of them and looking at whether there's need to upgrade standards, whether there's need to look at uses and so on. So that would be the extent of the review that is being done on the East-West corridor, but not that there's a East-West corridor draft plan as such.
Thank you. And in relation to Greenvale, could you assist us by indicating what, as you're aware, planning approval was first refused and subsequently approved. The first application had contended for development of about, I believe it was, I do apologize, 73 hectares with an excision of 41 for residential use. And the final approval granted was for the development of 79 hectares with an excision of 52.03 for residential use. Could you share with us what influenced the change in the enlargement of the development as approved?
I would not be able to, at this point, indicate what influenced the change in terms of the enlargement as to why it moved from 41 to 53. Without actually looking at the file, I wouldn't be able to say why it was, the size itself was changed.
And would you care to provide this committee with
Sure.
that information subsequently?
Sure.
There's two final questions. Again on Greenvale, could you indicate whether the Town and Country Planning conducted any post-construction inspections at Greenvale?
For clarity, could you indicate when you say post-construction, what exactly are you referring to? Because we deal with land use, and once approval is granted, then the conditions which we would say you need, water, drainage, and so on, once those things are satisfied and the structural issues are addressed, the regional corporation will issue a completion certificate. There is really no involvement for Town and Country Planning Division at that stage. So that's why I'm seeking the clarification in terms of to what you're referring actually.
You have, by seeking the clarification, you have given it. Thank you very much. The final question I want to ask is this. Again, it may be that your answer would be that it's not a matter for Town and Country Planning, and I would then ask the regional corporations perhaps to answer. In the light of the Greenvale circumstances and what has transpired, what mechanisms are there or have there been put in place to ensure that the planning policy and guidelines are adhered to by, for example, the HGC as it relates to housing development?
My pause is to make sure I think before I answer. Certainly, in the case of Greenvale, construction began before permission was granted. So that, again, because the agency is a sister agency, you would want to work closely to ensure that going forward, that state agencies do not begin development without permission. So that's one of the things that I think you'd want to ensure, and we'd want to work. And I dare say that has definitely, I would say, improved. We actually have a unit, a 2-person, 3-person unit that deals with state matters. And so working in close collaboration with the HGC, we are trying to avoid those kinds of things happening. And I think when you look at the results of Greenvale in terms of what has happened, I think there may be a greater appreciation of the need to, in this case, AGC, to ensure that all the approvals and so on are granted before actually starting development. The second thing from our end, what I know we have actually instituted, and it is as a result of what happened there, and it's a policy position that we are developing, what we are calling is a no-build zone. And so we are looking at those areas that you definitely shouldn't build in, and putting forward to our minister a position whereby this should be the policy going forward as it relates to those areas that can be seriously considered as no-build zone. So to answer the question, those are the two things that we will be doing from the point of view of AGC, working more closely with AGC to make sure that development doesn't begin without planning permission. And as I said, that has definitely been happening, and they've been working with us as far as that is concerned.
Thank you very much.
Okay, I just want to ask the PS from the Ministry of Rural Development and Local Government with respect to the municipal corporations taking over the responsibility for the general maintenance of private developments and state developments. And from your submission, what we were told is that a regional corporation should take into account that the developer has got final approval and a completion certificate before they take over. In municipal corporations where you don't have a city engineer, how then does one assess that the infrastructure is satisfactory for a municipal corporation to determine that this is a development that they could take responsibility for without the state therefore adopting something that is really very poor.
Those matters are referred to the ministry responsible for highways, Ministry of Works, and for someone to approach us, they have to prepare certain documentation with respect to the infrastructure specification, the roads and drains, and that is sent to the Ministry of Works. So they would.
If you don't have an engineer, you rely on the. If a regional corporation doesn't have an engineer, you rely on the Ministry of Works.
We rely on the Ministry of Works whether we have an engineer or not. It is required by law.
All right.
The Highways Act.
All right. Okay. And that will cover drains and roads.
Yes.
All right, because that wasn't there in the submission.
Okay.
So thank you for that. And in terms of, I've seen that San Fernando acquired 3 developments between 2013 and 2018. And for the same period, ARIMA acquired. And I think the point we need to appreciate is that when we talk about it, it's not that they're taking, the lands are not vested in the corporations, but it's just that they are taking the responsibility for the maintenance and upkeep of the infrastructure.
Yes, Chair.
Yeah. Are any performance bonds at all taken for any period of time from the developers as one of the requirements?
Well, in most instances, requests are made by members of council and the residents of a neighborhood. In most cases, the developers, because there is there is no provisions for the taking of a bond in the present act. So what happens is that the developers will make their money and move on.
All right. So could you give us a list of the documentation and undertakings, if any, that are required to be given by the developers when applications are made for takeover? And let me ask, when you take over responsibilities, does a corporation have to take into account what would have been its budgetary allocation for the particular fiscal?
Yes, Chair. When it is taken before council, that is taken into consideration because an estimate as to the cost it will take to repair or assume responsibility for maintenance is taken into consideration.
Within the fiscal. So if it is that within the fiscal, you don't have the allocation for that, what happens?
Well, I guess we'll work with other corporations or refer it to Ministry of Works if it's a case of an emergency, that there is a crisis that needs to be addressed.
Yeah.
We mobilize resources.
All right. And if not, what, it waits for until it's inputted into our next fiscal? What do you do?
Yes, well, we actually do estimates every year, as you're aware, and that would be put into the work program.
Okay. All right, thank you. Member Rambarat.
Thank you, Chair. I just, I've listened to the statements on the existing legislation and the legislation that still has to be proclaimed. And in most of the debates I have participated, I always make the point that we could make, the legislators, and I'm one, could make the very best legislation, pass the very best, but we have no control really over the implementation of it. And this issue of residential development without permission highlights that, because both the Permanent Secretary from Rural Development and the Deputy Permanent Secretary from Planning and Development has pointed to the fact that the existing legislation, the Town and Country Planning Act, does not provide for you to take action in relation to advertisements. Well, the new legislation doesn't provide for that too. So essentially what you're telling me is whether it's existing or incoming, you would not be able to do anything. So I want to refer you to Section 16 of the Town and Country Planning Act. And it reads, where it appears to the minister that any development of land has been carried out after the appointed date without the grant of permission required, or that conditions subject to which the permission were granted in respect of the development have not been complied with, then the minister may, within 4 years of the development being carried out, or in the case of non-compliance with a condition, within 4 years after the date of the alleged failure to comply with it, if he considers it expedient to do so, having regard to the provisions of the development plan, serve on the owner or occupier of the land a notice under this section. The opening words are, where it appears to the minister. So if somebody is bold enough to say in an ad, we have no approvals, isn't that sufficient to draw the minister's attention to the fact that Section 16 could be invoked? Section 16 provides for it.
Chair, if I might, if I may.
Right? That's the first thing I would say. And then I would ask, please, Chair, through you, if you can provide to the committee a listing of the action taken under Part 3 of the Town and Country Planning Act against residential developers between 2010 and 2018. So I repeat that. Through the chair, I would ask if you could provide the committee with a listing of the action taken under Part 3 of the Town and Country Planning Act against residential developers between 2010 and 2018.
Okay, so I think we will take that response in writing from the Town and Country Planning Division. And I think also in terms of Section 16, which the member referred to, I would also ask in writing if submissions would be made on how that section could remedy the issue that was raised by the member. Okay, so are there any other questions?
Chair, may I just
yes,
make a comment? That particular Section 16, I can tell you, is currently engaging the attention of the minister in terms of the correct interpretation, if I might call it that. So I know that that is currently before the minister and the legal department as we speak. So I just wanted to add that.
Thank you very much.
Chair, if there's one more comment
yes.
I can make on the same that the member Rambert was making about the Section 16. One of these scenarios that I have encountered in discussing with people who have run into this problem is that while we're focusing on actual physical work is being done to execute the subdivision, what some of these people do is on paper, they do it. And it doesn't come under the radar of actual work being done to serve a notice. So they hire a surveyor and they subdivide and they sell the lots to the people even before they do the physical development so that the law wouldn't come into play to say to serve a notice because the subdivision, the drains and the roads is not being implemented. But by the time the people get around to, they get all the money from the people and then they would have sold out all the lots. And then sometimes people are left holding a piece of paper in their hand without actual infrastructure in place. And what is happening is that some of these documents are actually registered and tendered into, the deeds are somehow being registered in legal affairs because you see them coming with a deed stamped off and so on. I've seen some of those deeds where, without having the town and country planning approval and the subdivision finally approved by the regional corporations, that these documents have been registered. So there's a gap outside of the town and country planning and the regional corporations where things are being done like that. And that's something we need to look at.
Well, in fact, this contribution took me to a question that I had forgotten I wanted to ask both agencies in terms of the existence of a fraud policy and the existence of a conflict of interest policy in each of the agencies, and thirdly, a risk policy. So that I would ask if both the Town and Country Planning Division and the Ministry of Rural Development and Local Government could submit to us in writing responses on the existence of a fraud policy in their respective entities, and if there have been any recent instances of fraud, and how has that been dealt with. Of course, we understand that if there are ongoing investigations, one may not be able to elaborate, but at least we can be told that much in terms of also conflict of interest and how is risk, the assessment of risk, built into your policies and your guidelines and procedures. Okay, so I guess because I anticipate that everybody should have, I would ask that you submit it in writing. Okay, what these policies are. I therefore want to invite both the PS of Town and Country Planning Division and also the PS Ministry of Rural Development and Local Government to make any closing statements which they wish. Thank you.
Chair, I would just like to say that on behalf of my team, we are very happy to have been here, and we thank you all for the opportunity. It has indeed raised and highlighted a number of issues that we have made a commitment to looking towards really improving the existing systems and processes towards really delivering a better service to the public. Thank you.
Chair, members, I'd also like to take the opportunity to thank you all in terms of getting our team to contribute also to positively aligning with some of the concerns you have and addressing some of your concerns. And I thank you for that opportunity.
And Mr. Chidi, I'm sorry, you are really PS Ministry of Planning and Development. So I want to bring this part of the meeting to a close. I want to thank the PS Ministry of Planning and Development, the Deputy PS, the Director of Town and Country Planning, and the Assistant Director. I want to thank the PS of Ministry of Rural Development and Local Government. Don't mind you all have that name so long you realize the challenges it poses to all of us. The CEO from the Shogunas Borough Council and also the Borough Corporation. I want to thank the, I thought you were city engineer, but if I stretch in my eyes, I've seen the building inspector, Port of Spain City Corporation, and all the other officers for coming and having such a lively conversation with us and with the members of the public. You know, planning is always something that excites a lot of conversation in the national community. I want to thank the members of the media who remain with us and the members of the listening public. In terms of the additional questions, the Secretariat will forward it to the PSs with the timeline for delivery. And let's hope we'll be able to give to the people of Trinidad and Tobago a better service, and also, as the Deputy PS says, for them also to recognize that there are benefits. It's not just a bugbear. There are benefits that redound to all of us from proper planning and for compliance with the requirements and the guidelines. So I want to bring this meeting to a close. I want to thank you all and to wish you all a safe journey home.